All right, good morning, everybody. It is Friday, our favorite day of the year. Although, if you're like most of us, Friday means nothing because we work 7 days a week. But regardless, this is Josh Carpenter from Carpenter and Associates. I am here. I'll just let everybody else introduce themselves, and we have a special guest today, and I'll introduce him when everybody else is done. Todd Cohen is here. He's sitting back, kind of taking some video. We are out of microphones temporarily, but we will fix that here forthwith. But you guys go ahead and introduce yourselves.
I am James Metcalf. I'm an associate here at Carpenter and Associates.
Brian Sherman, also the same. Been doing this for 25 years this month.
Daggone, we are old.
Yeah, we are.
All right, and also with us today is everybody's dear friend, the Honorable and highest of high, Your Highness, Your Majesty, everything, Judge, the Honorable Bill Harris.
Also older than all of you in the room.
I mean, that might be true.
Well, it is true.
We don't know. I don't know. I'm not taking.
No, I do know.
Well, I know you're older than me, but you're definitely older than James because James is like 13.
Yeah. 13 and a half.
There we go. All right, so we were having a little bit of discussion here prior to starting the podcast, but basically what we're doing is we're talking about lawyers today, right? And so Brian had a really good idea at the end of the last episode about cases that we won that we should not have won and cases that we should have won but we did not win, which kind of a sore subject for most attorneys, if we're being honest, because attorneys tend to be pretty proud people. And we want to act like we're going to win everything. We don't. It's impossible to win everything. It just doesn't work out that way.
I mean, yeah, because I still am kind of irritated that I did not see a parade outside of our office for National Lawyers Day. It still irritates me, but I'll get over it, I guess.
I think we should just be all happy that we didn't get shot on National Lawyers Day.
That's fair.
Just use this for target practice. All right, so we kind of had a little bit of a discussion here, and oftentimes cases hinge on the lawyer, which a lot of people don't necessarily like to believe or anything else. But I know as a young lawyer, when I started out, it was an interesting thing for me because when I opened my practice, I was still pretty new, and I used to go to court and watch other lawyers, right? And I'd watch the lawyers that won a lot, and then I'd watch the lawyers that lost a lot, and I'd make mental notes of, oh, this is what you have to do, or this is what you don't do, and that really helped me a lot. And it's been interesting because you don't see lawyers doing that. But when I was a young lawyer, a lot of lawyers would do that back in the day. And yeah, I know it's a quarter century ago or whatever, but the reality is it was the opportunity to learn from people who had a lot more experience. I didn't have a mentor, right? And so it was the opportunity to go and say, oh, man, Brian's fantastic in court. This is what he does. James is great. This is what he does. Josh is terrible. I don't want to do what he does, right? And so you go in, and I learned a lot of things that way. I learned the importance of establishing a relationship immediately with the court staff, the jury, everybody else. Like controlling the courtroom is my kind of terminology I use now. But you walk in, and you have to have charisma, and you have to be engaging, and you have to, you can't just be a grumpaluffagus all the time. It just doesn't work that way. And the attorneys that are really angry all the time that you see on TV, they don't win. I don't care what anybody says. They don't win. They irritate everybody, including the judges, including everything else. And so you go in, you have to be engaging. Much like time as a police officer, I think the law of the jungle kind of applies to being a lawyer. If you treat people with respect, 99 times out of 100, they're going to treat you with respect back. Now, all that said, that has a lot to do with whether or not you win or lose, but I personally believe that winning or losing a case comes down to preparation and your ability to communicate. And so what we're talking about today is we can share some war stories and everything else, but really what makes a good lawyer great, what makes a great lawyer greater, and what are some war stories and types of cases that we've seen win and lose. And Judge is going to have some awesome insight on this because at the end of the day, he's been on the bench for, I think, 312 years.
About that, yeah.
And he's been practicing law for, I think he practiced law back in Normandy before,
I was in-house counsel for William the Conqueror.
Oh, okay. Yeah, just make sure. But no, in all seriousness, Judge is a very, very accomplished trial attorney. He was with the U.S. Attorney's Office for a while. He was on a task force where he worked predominantly with the ATF at this, and quite a bit with DEA also, though, I think. And but he's had some jobs that are just pretty prominent, as well as being a prosecutor, as well as being a judge for, I think, 14 years now?
16 years.
16 years. Good gravy. And he's heard every type of case you can hear. So,
Well, Josh, I kind of want to step back because I know it's a kind of misconception for those who are not in the law realm. Once you get out of law school, you know exactly what to do. You can handle this motion. It's no problem. It's just like law school. Well, you fail to learn is you learn nothing of being an attorney in law school. You learn how to research. You learn how to say just enough stuff to get yourself in trouble and start offering advice before you're an attorney. But you don't know how to be a lawyer. And I mean, you said you had to watch. For my last firm is really when I really got to understand how the whole mechanism goes, because day one, my boss sits me down and says, "We're doing this case. They filed this motion with these exhibits." He flipped the rule book to hearsay rule. He goes, "You tell me each argument for each piece of evidence," and then left. And I was like, "I don't know what I'm doing." He's like, "That's what I'm trying to show you. You don't know what you're doing. This is how you start learning the process." And while many law students want to pretend like that the movies will show that they know exactly what they're doing if they're pre-law or if they're in law school, it's like, you don't know jack.
Yep.
You know about the subject somewhat, but you'd have no idea how to start doing motions or anything else.
well, and then even after a couple of years, if you don't have the right kind of guidance as an attorney, you still have no idea what you're doing. I mean,
No.
we probably all of us have been 20-year attorneys that don't know what they're doing, right?
Oh yeah,
And
I still get hit with some rules every now and then. I'm like, what's that rule? I have to reread that.
Well, that's why they call it the practice of law. Practice, because you never totally master it. I mean, I have lawyers that appear in my court that are 40, 50, 60-year lawyers. I've got a lawyer that appears in my court on a regular basis who's 96, right? He still practices law. He'll tell you that. I've been doing this for 75 years, and I don't have all the answers all the time.
Well, and I think there's also something that happens in law school, and a lot of a lot of students like to compete in mock trial competitions, and you do your mock trial arguments usually to other lawyers, and sometimes you can get some judges in at the law school, and you're really concerned about making points and scoring and making every objection and doing everything you can to maximize whatever tally that they're making in these mock trial competitions. And I remember the first year that I came out, was watching a senior partner who was a fantastic trial lawyer in court, and I kept thinking, why is he not making all these different objections? Like we were taught in law school, you object to this, you object to that, you got to score points, you got to score points. And I asked him about it because at some point, I'm going on a tangent here, but the witness was being non-responsive, and he asked the question over and over again. He objected the first time, but he would stop objecting, and at one point he just had a wry smile on his face, kind of shrugged his shoulders, sort of gave a little look over to the jury, and I just realized in that moment that he wasn't making points, he was winning his case, and that was just a completely new thought for me that I think gets lost in law school.
Because it's no longer a scorecard. It's actual people saying yes or no to your arguments.
And it's also engineering the jury. It's also manufacturing the best presentation of your case that you can.
Well, and you need to understand, too, that juries, especially juries, not so much judges, but especially juries, when a jury hears an objection, they think you're hiding something, right? I hear an objection, you're making a legal objection, you're protecting the record, you're protecting a client privilege statement or something. I know what you're doing, okay? Juries don't. They think that attorney that's making an objection is hiding something. And so juries become very suspicious of attorneys that just keep objecting and keep objecting and keep objecting, especially with younger lawyers, as you just said. You want to object to everything. And quite frankly, almost every question that's asked, almost every answer that's given is somehow objectionable, whether it's non-responsive or whether it's hearsay or whatever it is, right? But that's not always necessary, and it's not a good practice. If it doesn't hurt you, don't object. Because if you do object over and over again, you're going to irritate the jury. The jury is going to become very suspicious. As a trial judge, I get very frustrated with lawyers that just object all the time just to be objecting because it unreasonably delays the proceeding. And nobody wants to waste anybody's time.
Makes that 2-hour trial now a whole day.
Or 3 days.
This should be a 30-minute hearing, and we've done this now for 3 hours. And at some point in time, if you're before a judge who knows what they're doing, the judge will stand up and take control of the hearing and finish it for you, and it's probably not going to go in your favor.
Well, and talking about good lawyers, I've been in enough depositions where you'd have somebody constantly objecting on the record and
Objection form.
yeah, and just slowing the whole
Every
process
question.
down. And I'd look at him and I'd just say, listen, I'm just going to ask the question differently. Like whatever you're doing here is just slowing down the process, but I'm a good enough lawyer that I can figure out how to ask the right questions so that you can't object. Just let's get through this. So, so a good lawyer will hear the objection and just work around them.
See, I've been taught that to like for in a depot to object to form basically to everything because it's always wrong, so it protects the record. And
But nobody's ever going to read that record. That's the funny thing.
but it depends on the case, and if the other attorney is kind of just being like someone you just don't like, let's just say that for lack of better terms, you're like, yeah, screw it. What are you going to do about it? And so you just do it because it in a way it eliminates their ability to cite directly to that quote that happened in the depot and makes it a whole thing about if it's legit or not. But in reality, it's probably getting in.
Well, let me give you the perspective from the bench in that regard. I cannot think of anything that irritates a judge more than discovery fights and wastes of time. You know, I hear these motions to compel. Well, we're not going to give you our bank records. Well, this is a divorce, and we have to value the community estate and determine the assets that are in the estate. How come you won't give them the bank records? Well, we don't think they're relevant. Well, it's a divorce case, guy.
All assets are relevant.
Everything's relevant. Why won't you? Well, we're not, we didn't think we needed to comply. Dude, why are we here? Why are you wasting my time and the lawyer's time not giving up your client's bank records when you know they're relevant in this proceeding? Again, it's just another way to irritate a judge, and that's just not something that you want to do.
Well, I've been a part of a hearing for one of our baby attorneys here, and I had to fill in for that attorney, and they made objections to our second round of discovery. And at the hearing, the guy all but said, well, I didn't think the objections were completely legitimate, but I had to do it to protect my client. And what he basically admitted is, I just did it to force a hearing, so he'd have to pay.
Then you've just bought yourself some sanctions right there.
Right, and I should have asked for him there, but basically I just went, Judge, it seems like he can't even make a coherent argument. It seems like I win. The judge just nodded her head, yeah, and just signed my order right there. He's still talking. She's already signed the order. Like, there you go.
Well, Judge, do you have some examples of cases that sort of stick out in your mind of a time where maybe somebody should have won a case but they didn't because of the lawyers, or maybe vice versa, a case that was won because of the lawyer, even though maybe the facts weren't there?
Not so much any specific cases, which it's kind of dicey to talk about specific cases, as a judge. But I can tell you, especially in family law cases, where I'm hearing testimony. I've been on the bench, say, for an hour, and I've got a fairly good idea of what's going on in the case. And I may think that the mom should prevail on a custody issue or modification issue, whatever. I think the mother should prevail. Dad is the petitioner or the movant, and Dad's attorney is very well prepared, has woodshedded their witnesses, has briefed the court on whatever strange issues are going to pop up, doesn't waste my time, asks the right questions, develops the record that I need to make a decision, because that's what judges do. We make a decision based on what is in the record, not what we think should happen, but what is produced during the hearing or otherwise placed into the record. If it's not in the record, I can't consider it. I can't use that to inform my decision. So I may be thinking to myself, Mom should win on this particular issue. But Dad presented his case well, was prepared, had handled the objections appropriately, briefed the court on whatever these odd, novel issues are, and Mom's lawyer just showed up and asked questions, wasn't prepared, really hadn't talked to their witnesses, and so Dad wins, even though my personal belief would be perhaps that Mom should win, but the record doesn't support it. That's the problem, is if you can't develop that record and put in that record those nuggets that the trial judge needs to rule in your favor, then the trial judge can't rule in your favor, even if the judge wants you to win. Got to rule for the other side.
Right.
Right. So, lawyers that are prepared are the ones that are probably going to win.
It's the old 6 P's, right? That we learn in the Army and everything, right? Proper performance prevents proper preparation. Proper preparation prevents piss poor performance.
And that's
Right.
and that's an axiom. Yeah, absolutely.
Yeah, because I mean, I've been taught by an attorney of like we in some ways you can see like, man, you're kind of overdoing it, this and that. Well, you took our own evidence that we're wanting to offer in, and we're seeing how could they possibly get this under the hearsay rule and start making arguments. So you're already preparing for that. So when they do, you can quote the rule right back. And even if you're right or wrong, the judge is like, okay, so we're actually having a real discussion here, not just the argument off the cuff about it should be in or should not be in, whatever it is. And I've seen a few documents that in my small tenure compared to everybody sitting at this table of, I can't believe he allowed that in, but he just bought my argument because I was ready to go.
Well, and you bring up another interesting point too, is almost as important as knowing the facts in the law that's applicable to your case is you've got to know your judge. Mm-hmm. Every judge has triggers. There are things that judges like and things that judges don't like. If you're in my court and you're a young, healthy individual over the age of 18, you're not missing a leg, you're not missing a hand, you don't have any significant mental health issues, why aren't you working?
Yeah.
Why don't you have a job? Why aren't you being productive? Okay, and so
That's not just yours. That's a lot of judges.
and I don't like that. Right, that really gets under my skin. Is why aren't you being a productive citizen? Mm-hmm. Why aren't you working? It means something to me that say I'm in a family law case, I'm hearing a criminal case, and they're asking me to set a sentence. Why aren't you working? That's just a pet peeve. Yeah. Lots of judges have pet peeves. Another one of my pet peeves is animal cruelty cases. I do not like animal cruelty cases. And the defense attorneys that practice in my court will go out of their way to do whatever they can do to keep me from hearing an animal cruelty case.
They know the ruling no matter what.
Because they know that bad things are going to happen to their client. Because animal cruelty cases, this is not defensible.
You're about to get some questions from the bench after it's like cross-examination. Like, no, I have a few questions now.
And I've given speeches before in contempt hearings or animal cruelty cases, whatever. It's like, did you bring your toothbrush? Because you're going to be needing it.
So what are some almost automatic triggers where you're like, all right, you're done here?
Well,
aside from animal cruelty and anything, I'm talking about arguments that lawyers make or things that they do.
My biggest pet peeve, as far as that goes, is wasting my time. Don't waste my time. If you have a motion, that you need relief from the court, I will let you put on whatever you want to put on. I will let you put your case on. I'm a firm believer in letting the lawyers do what lawyers are paid to do, which is present their case. But if you're repeating the same thing over and over again, or if you're disorganized, or you don't know what the law is, or you're just not prepared, then I'm going to be honest, and this is true, I think, for all judges, even though we may not want to admit it. At some point in time, we've shut you off because you're not moving the ball down the field, right? And so a good lawyer is going to know their judge, is going to know what the issue is going to be prepared, is not going to call 8 or 10 witnesses when 2 witnesses would do, right? You're more than likely to get the relief you want from the court if you're prepared and you're efficient with your time.
Right. I mean, I've been in front of enough judges now to where, Josh allows me, like I've said earlier, to kind of help some of the baby attorneys here. And they'll have their motion, it's 15 pages or so or longer. And I've had one say, so we're doing this hearing and it's their motion. What do I do? I said, have a 2 minutes or less elevator speech for this case. There's a good chance this judge has actually read it. There's also a good chance they don't care. They haven't read a single thing of you. But if you have the elevator speech ready to go, like broad brush, here's what I'm going to say today, then the judge may stop and go, all right, I have a question about that third point you made. And then he can start going directly to your actual motion. But if you're just trying to just read it verbatim, a judge, like you said, is just going to gloss over and shut you off.
There's some merit to that. If you're in front of a court and you're seeking relief or you're resisting somebody seeking relief, you ought to have, and this is true if you're trying a murder case, if it's a motion to compel in a family law case, if you're trying to get custody of your kids from your ex-spouse, whatever it is, your theory of the case, your presentation, really should never be more than about 3 central issues. And you spend your time litigating those 3 central issues, right? I don't need to know everything that's happened in your life since you've been divorced from your wife, okay?
Right.
Why should I give you custody of your 8-year-old child? I don't need to know that you scored 4 touchdowns in a single game when you went to Polk High in Chicago in 1965.
Did they win state?
I don't care. I don't care, right? I need to know why should I give this child to you? Why should I give primary custody of this child to you? Which means I need to know what your daily habits are. I need to know what your job is. What hours do you work? Are you married? Is there some other adult living in the home I should know about? Your income. I need to know those things. Those are important. And again, as a litigator, what are your 3 theories of the case? What are your 3 issues that you want me to hear? What are your themes? And if you're just wandering and going all over the place, then probably after about 45 minutes or so, and you're not moving the ball down the field, I'm going to call you out and I'm going to say, you've got 15 minutes.
Yeah.
Right?
No,
but if you're focused and you're on point and you're making sense and you're organized, I'm going to give you whatever time you need.
Right, because like you said, you're moving down the field and showing me your theory of logic. I may disagree, even as the judge, of your theory of logic, but you're at least showing me your work.
Yeah, you have a coherent presentation with as few central themes as you can possibly make, 2, 3, 4, no more than that under any circumstances, right? But if you're advancing the ball, if you're staying focused, you're only calling relevant witnesses, and you're prepared, you stand a pretty good chance of winning.
Judge, what's been your observation from the bench, good lawyering, bad lawyering, when you're watching juries? How quick do they lose the jury? How quick do they win the jury?
It has been my experience that juries will figure out a lawyer very, very quickly. And what you want as a lawyer, if you're practicing in front of a jury, is you want that jury to like you, almost more than anything else. Now, obviously, the quality of the case, the facts may not be in your favor. That's going to hurt. But if a jury doesn't like you, it doesn't matter how good your case is, because the jury's not going to want to do anything for you. The best prosecutors, the best attorneys get that jury to like them. And it almost has nothing to do with the facts of the case. How do you come across as a lawyer to a jury? And I'm going to give you a really good example. I worked at a very large law firm one time, and we had a gigantic lawsuit that we were trying. We were local counsel for a major international corporation, a name that everyone in this room and everyone listening to this podcast would recognize. Their lawyers came down from New York City. Their general counsel, their chief counsel, came down from New York City. We're in Texas, and we were getting ready for jury selection. This huge lawsuit. And these lawyers, the general counsel in their office, their lawyers insisted on doing jury selection. We're telling them, look, we're in rural Texas. You don't want a bunch of New York lawyers coming in here and trying to pick a jury in rural Texas. Let us pick the jury in rural Texas. And then you can put on your case. But we want to build that relationship with the jury, with the potential jurors.
Right.
Before it gets to the meat of the case. Okay, we speak their same language. We know who they are. Let us we want to handle jury selection. So these New York lawyers, and I'm using air quotation marks if no one can see me, these New York lawyers show up. They're wearing their $2,000 custom-made suits.
Lost them already.
And one of them was wearing cowboy boots.
Now you're a faker.
He had never worn cowboy boots before in his life. He was uncomfortable in cowboy boots. They were uncomfortable in front of this very rural jury, a jury drawn from a rural population. They lost that case, or we lost that case at jury selection.
Yeah.
A $1 billion verdict later, That's B with a billion. $1 billion verdict later, the general counsel from New York said, we should have let you pick the jury. So
Yeah.
juries are interesting creatures. They're greater than the sum of the whole, right? They're smart. They tend to figure things out. And if they don't like a lawyer from the get-go, you've got a pretty serious problem.
Well, I mean, it's just like seeing regular people. I mean, I don't really care which party they're advocating for, but if they don't like the candidate just because of their style, they're not going to listen to you even if you have good points because you've already brushed them the wrong way. I just don't like you.
I tried a family law case one time, 2 lawyers. One lawyer I would put in the category of barely competent, and the other lawyer is one of the finest lawyers in my part of Texas, in Northeast Texas. And that fine lawyer, one of the best lawyers I've ever seen, one of the best lawyers I've ever worked with, lost that case because his client, he represented the mother, his client wore shoes that the women on the jury didn't like. And that's what they told us after the trial.
Wow.
That if the mother was going to wear these kinds of shoes and dress like she was dressing, then she wasn't the best influence on the
Was
child.
she dressing like too uppity, or she was trying to like downplay herself?
She was dressing, let's just say, a little bit provocatively.
Gotcha.
She showed too much toe.
Yeah.
So
Yeah.
you never know. I guess the point of all this is you never know what a jury is going to set a jury off. And your best practice is to be honest and direct and upfront with the jury. Be friendly, right? Be who you are, because if a juror thinks you're being deceptive or you're hiding something, they're not going to want to, rule in your favor. And every lawyer is different. You can have different styles, and not every, there's not one particular style. There's an older lawyer that practices in my court on a regular basis. He probably hasn't opened a law book since the 60s, but it doesn't matter because he comes across as your grandfather. I'm your granddad. I'm never going to lie to you. You can trust me. Now, he doesn't say those words, but that's the impression that he leaves, right? And so jurors, they like him because he's like their grandfather, or they're like their, like their dad. And so he endears himself with the jury through that jury selection process, and throughout the trial, he's laid back and he's friendly, doesn't know the law. hadn't read a law book in years.
He just wings it.
He just kind of wings it, but jurors like him. And because they like him, they want to do something for him.
See, I've even heard that even when, because we were talking about too many objections in front of a jury, and they can kind of say, what are you hiding? I was kind of taught I've been taught multiple ways of how to do that in a hearing, trial, whatever it may be, of depending on who the jury is. Sometimes you just kind of get up and say, Your Honor, I object, and you're coming off that way. It's like, I'm just going to pause this real quick. But if you come up just kind of screaming, you may get that more thought from the jury of, what are you hiding? But if you come up like, time out, hold on, let's talk about this.
Just keep in mind, again, juries don't understand why you're objecting.
Right.
And so they think you're hiding something. And so you only object when you have to in front of a jury, right? Or you voir dire a jury. Ladies and gentlemen of the jury, you're going to hear me objecting a lot in this case. There's a reason I have to do that. I'm protecting the record. I'm protecting my client. The law requires I do that. Are you going to hold it against me if I make objections in these cases?
Yeah.
In this case. And so the jury is going to, okay, now I understand why you're making these
You've already
objections.
prepped me for it.
You've prepped them for it.
In my experience, I don't have as much experience as a judge, but I've done a couple hundred jury trials, and I'll tell you, it really does come down to the way you tell the story. And so, as I've been teaching other lawyers and things like that, I've offended a lot of senior attorneys and even a couple judges in the past, where I've explained even on the record, I'm like, this is all about a story. This is their version of a story and our version of a story, and it's going to come down to who's the better storyteller, and who can incorporate evidence or facts or pieces or whatever, who can tell that story more effectually, because whether it's through objections or whether it's through shoes. I lost a jury trial because of a pen at one point. It was a misdemeanor criminal case at the beginning of my career, and I got a really nice, I don't remember what kind of pen it was anymore, but it was like a metal nice pen, and when I hold the jury after the fact. They're like, well, if you could afford that pen, then he's paying you a lot of money. If he's paying you a lot of money, he's obviously guilty.
Oh,
that's some of the logic that you run into, right?
You never know what's going to set a jury off.
Yeah.
You never do.
Yeah, and that's why a lot of people, it's very interesting to me because a lot of people are like, oh, Judge Harris is biased. He's a piece of garbage. We never want to have him rule. Let's get in front of a jury. Are you out of your mind? Like, juries are terrifying creatures in and of themselves sometimes because you truly have no idea what's going to happen. I was joking around about a wheelchair case earlier today in an office meeting, and just briefly, what happened is that there was a heavily mentally and physically disabled vet, and he was angry at the world, right? And this guy came into court, first time I met him, he peed his pants on purpose to offend both me and the judge, right? We go to trial, they have this guy on camera. I mean, the prosecutor had this case dead to rights. But the prosecutor that argued the case was such an amazing jerk. And that's about the softest word I can probably say. Like, I want to say many other words, but his attitude and his presentation was so poor, and he was so just acrimonious about everything. He wanted to argue and just blah, blah, blah. I don't know how he's done in other jury trials, but on this one, he almost lost a case where they had hard video, open and shut.
Yeah.
And the jury still pondered for a while about, you know what, like, yeah, I mean, this guy might have done it, but man, this attorney's a jerk. You know, and so he almost lost that case. And so it's been one of those things where you have to be able to tell the story, but you have to be engaging to tell the story, right? You have to learn how to play with the audience, know your audience, know who you're talking to. If you're going to do a bench trial, for example, it's a completely different way to prepare. It's a completely different way to approach, different way to object. Everything is different because ideally, I'm going to say it that way, because sometimes you do bench trials in JP court in Texas, and that's the wild, wild west.
They don't have to be a lawyer. Yeah.
Some of our lawyers, I've literally had trials in front of plumbers, football coach, and some other things before, and it was bananas, right? And so you never know what's going to happen. But if you're in front of an experienced judge or a jury, the way you portray that story and the way you help people visualize things is so important. And that's one of the benefits of being able to go to court and like listen to attorneys. That's one of the benefits. Frankly, that's why a lot of people, or especially trial attorneys, are starting to do things like podcasts, because it's important that people can hear you. Like, is James really a good lawyer? Like, let me listen to him. Yeah. Or how's Brian? Judge Harris, what's he like? Let me listen to him on this podcast. Or let me go sit in his courtroom. Because if you ever go to a lot of the courthouses, there's just random people sitting in the courtroom, and the reason why is because they're trying to get an idea of what's going to happen in the court, right? Those are pretty smart people, and even a lot of pro se people do it. Now, I've had cases in San Marcos where we had a guy who was from California, and this is one of the funniest things that I've ever seen in my entire life. Hardcore, like Shiite liberal Californian comes to court in super conservative San Marcos courtroom, right? And he shows up, kind of like you were talking about the big city attorney. He shows up, super tight jeans, Wranglers, of course. Brand new cowboy boots. He can't walk properly. But then he has. Do you remember the shirt? He has. We're laughing over here. He had a shirt that was the flag of Texas. But he hadn't even bothered to iron it, so you can still see like the fold marks. The fold marks on the
Please
shirt.
tell me he wore a cowboy hat too.
He did not wear a cowboy. Did he have a cowboy? He did. And so he walks into court and he starts trying to argue. And one of the other things this guy did, he's been opposing party. He was for a decade and a half. I've known him throughout multiple states, and but he used to be a practicing Mason. And so one of the other things he does whenever he walks into court, he tries to like throw Masonic gang signs or whatever he's doing, and so it's really funny because he says you think he's twitching, but he's making all these weird symbols and signs, like trying to get favor with the court or something like that. But that backfired in front of him every single time. He always tried to play that game, like be the wannabe chameleon. And I agree with Judge. I think the best thing that you can really do is, you have to be prepared, you have to know the law, you have to know your facts, but you also have to know who you're talking to. And you have to be able to tell the story accordingly, because if you just go in and, start being super rigid or super overly technical on things you don't need to be, you're going to lose the judge, you're definitely going to lose the jury. Sometimes you might even lose your client, right?
So
that happens.
Let me add something in real quick, just the flip side of that coin. A lot of lawyers lawyers tend to be kind of type A personalities, very alpha male, alpha female, however you want to characterize it. And they want the attention drawn to themselves.
Mm-hmm.
I know one of the finest criminal defense attorneys in the state of Texas, recognized across the country as one of the very best of the very best of the very best. A very honest, very ethical man. I did a lot of work with him when I was a prosecutor and as a judge. He's retired now. He wore the same thing to court every single day. Same thing, same clothes, different clothes, obviously clean,
Right.
but the same outfit every day. You know, blue suit, red tie, kind of thing.
That was his uniform.
That was his uniform. He was a Marine. But the reason I asked him one time, why do you do that? He said, because the case is not about me. I don't want the jury paying attention to me. I want them thinking about my client and thinking about the government's case.
Right.
So he's the exact opposite of a lot of trial lawyers who want to get close to the jury and want the jury to like them and pay attention to them and do what they say. This guy was completely the opposite, and a fantastic lawyer. World class,
Right.
highly regarded lawyer, very successful. He didn't want it to be about him at all. He was kind of quiet, kind of neutral, very precise in what he was doing. He wasn't flamboyant and screaming and yelling and jumping up and down, right? He just got in there, he did his job, he did it better than anybody I'd ever seen. He wore the same thing every day because it wasn't about him. It was about his client and about the case.
Well, that kind of reminds me of where you're going with that, Judge, that it really sometimes isn't about the lawyer, and you can have terrific lawyers, but if the judge or if the jury just doesn't like the client, that could throw great lawyering completely out the window as well. About 10 years ago, I tried a car accident in Tarrant County, which is a really conservative venue. And we were the plaintiff. We had a lady that was T-boned and had some physical personal injuries, and we knew wasn't going to make a great appearance. She was kind of unkept, and she dressed provocatively, and she was really sort of dyed her hair different. Like, we just knew that she didn't match the jury pool there, and we did everything we could to tone her down and to explain, your case is on the line, your story is on the line, but you're not going to present it in a way that they can digest it. You got to tone this down. We did everything we could. So we get to the courthouse, we try the case, we put her up, and they hated her, and we knew it from the beginning. And on the flip side, the defendant, polished military veteran, beautiful, clean-cut guy, suit, had a little American flag pin on his lapel, and the jury loved him. And you know what he said? I did it. I T-boned her. I have no way to defend myself. It was all my fault. And he was just super honest. And you know what happened? We had liability. We had everything in our favor. They gave her 0. And we tried, and she had a low-cut shirt on that day, which we told her not to wear. She had like a tattoo from her breast kind of extending out into her chest area, which everybody can see. And she just didn't match the jury. Maybe that could have flown in a different jurisdiction somewhere, but we knew it. We did everything we could to tone this down, and they zeroed her out. Now, fortunately, as you know, you try to be the best lawyer you can. We kind of sensed what was happening, so we pulled opposing counsel back to the back of the courthouse on a break, and I struck a high-low with him. I said, listen, if I win this case, my damages are capped at X, but if I lose and you pour me out of here, I want at least a minimum of Y, and will you agree to that? And we'll just go on and try our case. But that was me scrambling on a case that I had clear liability. The guy admitted it in the box, and I knew something was just not going to go right. So we at least got her a small recovery, even though the jury gave her 0. But I had to scramble on that one.
That's tough. All right, well, we've been chatting it up for about 40 minutes, so I think we'll call it on this one. Just for some housekeeping issues for the podcast purposes, we are going to be adding video. We are going to be adding some sounds and everything else, and actually being able to edit this and everything else pretty soon here. So we appreciate everybody's patience as we go through. But again, we want to sincerely appreciate Judge Bill Harris here. He's been great. We'll be having him back for more.
Thanks for coming down from your throne to talk to us, little peasants.
Don't look at him.
Just
We're not allowed to
don't,
look
sorry,
don't
sorry.
look directly at me when you say that.
But as always, thank you to Brian, James, Todd. It's been great, and many more to go. Thank you, everybody.